In every civil lawsuit in South Africa, there must be a foundation, a document that clearly tells the court who is suing whom, for what, and why. The document is called a particulars of claim. It is the very heart of the plaintiff's case, much like a charge sheet in criminal law. It sets out the case that the defendant must answer. In today's session, we'll break down everything you need to know about this powerful document, including what a particulars of claim is, when and where they are used, the structure, rules, and format to follow, as well as how to approach drafting it like a pro. Whether you're a law student, paralegal, or budding litigator, you're in the right place. Welcome to City Education, a channel for learning in all forms, shapes, and sizes. Let's get into it. Before we dive into the particulars of claim, let's rewind a little. In our previous video, we explored the difference between an action proceeding and application proceeding. Remember, action proceedings are used where there is a dispute of facts that must be resolved through oral evidence and a full trial, and they always begin with summons. Now there are two types of summons, simple summons and combined summons. These were touched on in our previous video. In that same video, we established that the particulars of claim, together with summons, makes up the combined summons. We also established that they are governed by Rule 6 of the Magistrate Court Rules, as well as Rule 18 of the High Court Rules. So when do we use particulars of claim? The answer lies in the type of claim the plaintiff is bringing before the court. In South African civil litigation, claims are divided into two broad categories: liquidated and unliquidated claims. The liquidated claim is one that involves a fixed, clearly determinable amount of money. For example, an unpaid invoice, a loan repayment, or money owed for goods sold and delivered. In these cases, you will use a simple summons, where the course of action and amount owed are stated briefly. No separate particulars of claim is needed unless the defendant contests the claim, in which case a declaration is filed later to explain the details. Unliquidated claims, on the other hand, are more complex. The amount owed isn't fixed or easy to calculate, like in the case of a breach of contract, derelict, medical negligence, or defamation. For these kinds of claims, the plaintiff must issue a combined summons, which is accompanied by a particulars of claim. This document sets out the plaintiff's full case in numbered paragraphs. It will also establish who is being sued, why, and what relief is being sought. Now let's get into the structure of a particulars of claim. Always note that every paragraph is numbered sequentially and must follow a logical flow, all except for the prayer. The prayer is never numbered. Never. Moving on, always label particulars of claim right at the top of particulars of claim. Now the citation containing the parties, the case number, the jurisdiction, and so on and so forth, that will be found in the summons. Remember, particulars of claim go together with summons to form combined summons. Moving on, the first paragraph is the citation of the plaintiff. As you can see from our example, the plaintiff is Sipho Mokoena, an adult male furniture manufacturer residing at 12 Riverside Street in Tetwa, Eastern Cape. Now, the second paragraph is the citation of the defendant. Yet again, you can see the defendant is Thabo Dlamini, an adult male businessman residing at 89 Highland Road, East London, Eastern Cape. This is always the case when it comes to particulars of claim. The first and second paragraph are the parties involved. Moving on, you have the jurisdiction. If you look at paragraph 3, it says, "The Honorable Court has jurisdiction to hear this matter in that the contract giving rise to the plaintiff's claim was concluded and is to be performed within the jurisdiction of this court. Now the court will be in the original citation, which is found in the summons. So basically this is enough for the particulars of claim. No need to write the court in question yet again. Moving on to the fourth paragraph. This paragraph covers the locus standi, legal standing, which explains why the plaintiff can sue. Now let's look at it. Paragraph 4 says, on or about 12 February 2024 and at Mthatha, the plaintiff and defendant entered into an oral agreement for the manufacture and delivery of custom-made office furniture. This paragraph shows us that a contract was concluded between the plaintiff and defendant. The contract between the two raises legal obligations between them. Thus, they have locus standi in the matter because they both have a direct and substantial interest within the matter. Now let's move on to paragraph 5. Paragraph 5 gives the facts that give rise to the claim. These include where and when the contract was made, who represented each party, the terms that were breached in some cases, and the plaintiff's performance. Now let's look at our paragraph 5. The plaintiff was represented by himself and the defendant was represented by himself at the time of concluding the contract. Paragraph 5.2. The material express, alternatively implied, alternatively tacit terms of the agreement were as follows. Point 1. The plaintiff would manufacture and deliver a full set of custom-made furniture, including 5 executive desks, 10 office chairs, and 2 boardroom tables. Point number 2. The defendant would pay the plaintiff the sum of 150,000 rand for the manufacture of furniture. Point 3. The furniture would be delivered to the defendant's business premises at 45 Marine Drive, East London, on or before 31 March 2024. Point number 4. Payment would be made in full within 7 days after delivery. Paragraph 5.3. The plaintiff complied fully with his obligations in terms of the contract, in that he manufactured and delivered the specified furniture on 28 March 2024 to the defendant's premises at the agreed address. Now, if you zoom properly, you will realize that the facts giving rise to the claim were all included. We covered the where, the when, the who, the terms breached, as well as the plaintiff's performance. Now let's move on to paragraph 6. This is where the defendant's breach is stated. Looking at paragraph 6, it says, despite delivery and demand, the defendant has failed and or refused to make payment to the plaintiff within the stipulated period or at all. Thus, the defendant is accordingly in breach of the agreement. Now, paragraph 7 will look into the consequences and the causal link. Let's go through it. As a result of the defendant's breach, the plaintiff has suffered damages in the amount of 150,000 rand, being the unpaid contract price. Now, let's move to paragraph 8, which is the quantification of the loss. Paragraph 8 would sound something like, basically you can see it from the screen. The plaintiff accordingly claims 8.1. The payment of the amount of 150,000 rand. 8.2. The interest thereon at the legal rate at temporum mori. 8.3. Cost of suit. 8.4. Further and or alternative relief. This is the quantification of what the plaintiff is claiming from the defendant. Now let's move on to the prayer. The prayer states that, wherefore the plaintiff prays for a judgment against the defendant for, firstly, the payment of 150,000, interest thereon at the legal rate from 4 April 2024 to the date of the final payment. Third prayer is cost of suit, and the fourth prayer is fourth and/or alternative relief. Now this is the structure of a particulars of claim. Remember to take note that for good particulars of claim, it must answer the who, the when, the way, the why, the how, and the what of the claim being sought. Remember, different law firms have different ways of writing their particulars of claim. Some may even add a paragraph 9 where they'll explain the lengths they've taken before initiating litigation in the form of combined summons. Here, under your paragraph 9, you'd be mentioning things like your letter of demand and other forms or routes you opted for before settling for the specific route. But essentially, the structure remains the same. You have your parties, you have your jurisdiction, you have your locus standi, your course of action, your prayer, your addresses at the bottom. Now let's look at a few requirements for drafting a particulars of claim. The particulars of claim must be concise, complete, and clear. It must contain only material facts and no evidence. It must contain only the facta probanda. It must be written in plain, persuasive language. Each paragraph must deal with one issue, and it must follow a logical sequence reflecting the client's version. Now, let's look at the things you shouldn't include in a particulars of claim. Firstly, do not include immaterial or irrelevant facts. Secondly, as mentioned above, do not include the facta probantia, which is evidence. Thirdly, do not include a legal argument. Fourthly, do not include statutory citations or case law. Thirdly, do not include scandalous or vexatious matters. Lastly, do not include improbable or fabricated facts. Doing this could lead to an exception for being vague and embarrassing, or certain parts being struck out, or it could damage your cross-examination at trial. So above we dealt with the particulars of claim for a contractual claim. Now, what will a particulars of claim for a delictual claim look like? For example, negligence. Well, we won't get much into the structure because it's the same thing. You have your parties, plaintiff, defendant, second paragraph, and then you have your jurisdiction, after which you have your duty of care. Don't forget, before your duty of care, the legal standing. And then you have your duty of care, your breach of duty under, and then we have your causation, your harm or damage following that. Don't forget your quantification and your prayer. And most importantly, in the claim for damages under negligence, there must be a statement somewhere between your background which will demonstrate that the harm was foreseeable and not too remote. Another thing, which is optional in most cases, you can include in your particulars of claim is the necessary steps you took before choosing to go the litigation route. For instance, you may have drafted a letter of demand, you may have tried other ways to settle the issue, maybe tried to use alternative dispute resolutions, and so on and so forth. That should be stated right there. You can put it between your quantification and your prayer, or you can put it before that. Yet again, I repeat, different firms have different ways of writing their particulars of claim as well, but the structure is essentially the same. You have your parties, your jurisdiction, your locus standi, your background, and. While particulars of claim may play a central role in initiating action proceedings, they are not the only pleadings that can be filed during the course of litigation. This was established in the previous class as well. Now, depending on how the defendant chooses to respond or what complications arise, several related pleadings may be introduced. Let's explore a few key ones you may need to know. First of all, we have counterclaims. Now, a counterclaim is a legal claim made by the defendant against the plaintiff in the same action. The second claim that may be used is a third-party claim. Now, a third-party claim is used when a defendant, or plaintiff in some cases, believes that another party should share liability or be completely responsible for the damages. In such cases, the defendant has options like your misjoinder and non-joinder, but we'll get into those in the next sessions. The third type of claim that may be applicable is an interpleader proceeding. Now, interpleader proceedings are used when a person, often a sheriff or stakeholder, is in possession of money or property, but multiple parties are claiming ownership of it. Here, instead of risking being sued by both sides, the stakeholder brings the matter before the court and says, "I don't know who to give this to, you decide." The fourth type of related pleading is a provisional sentence summons. A provisional sentence summons is a unique pleading used when the plaintiff's claim is based on a liquid document, which is a written instrument like a check, acknowledgement of debt, or mortgage bond that clearly shows the defendant's obligation to pay. As you can see, litigation doesn't end with particulars of claim. These related pleadings allow other parties to respond strategically, join others into the case, or protect themselves when legal interests overlap. Understanding these additional tools can help you navigate the broader litigation landscape with confidence, whether you are initiating a claim, defending one, or managing complex legal relationships in the process. We've explored how particulars of claim are central to action proceedings in South African litigation. They form the legal foundation of a case, outlining who is suing whom, or what and why. You've learned when and why particulars of claim are used, how to structure them properly using clear, factual, and numbered paragraphs, what is included, what not to include, as well as related pleadings. Before we conclude, always remember that a well-drafted particulars of claim can make or break a case. As a legal practitioner, ensure that you master drafting it. That way, you are halfway to mastering litigation. This is City Education, your source for practical legal learning. Like, share, and subscribe for more.